For one thing, if the person has criminal record or has a negative immigration history where they committed fraud or they've been removed in the past, those folks aren't likely to get out. Um, in most cases, detainees don't get out very quickly. There has been a federal court decision that, for the first time, has allowed detainees who are being detained, usually waiting to be removed, and they they have they may be in jail for a very long time, and that's why the families are getting so involved, because today we're arresting people that have been here for 20 years, have never committed a crime or anything else. The only thing they did was enter illegally. And so in many situations, getting the person released is very, very, very difficult. If we had this discussion 3 weeks ago, we would be talking about the fact that judges are now precluded from granting immigration bond. But as I said, there is a federal court case now that says they do have discretion to grant bonds again. Now, ICE, on the other hand, has always had discretion to let people out. They can let people out and, for example, give them an ankle monitor, or they can let people out and have them report once a week to ICE. In a way, ICE is much more direct, and they make decisions very quickly. And I understand why people don't want to go before ICE, but since ICE has the ability to make this happen very quickly, it's usually worth it. As far as bond is concerned, you can also now file a motion with the immigration court. And so whichever one comes first, they can let the person out. Now, when I say let the person out, that's all, because they're still going to have a removal hearing. And if they entered without inspection, for example, there's no defense unless they apply for asylum or CAT or withholding. And so bond is an illusion. And if you take a bond case today, you're going to have to file in federal court. Because in order to get this federal court decision to be implemented, there must be a judge to make it happen. Now, once the court entered its decision and people could apply for a bond, the Department of Homeland Security took the position that the adjudicators can ignore what the federal district court said, and that even though the federal district court said this is nationwide, they've instructed their officers to ignore it. And so here you have government interference stopping the person from asserting their rights, which happens quite a bit these days, I might add. Then you have to go before ICE and try to argue it, or if you can develop new evidence that wasn't heard in the first bond hearing, you can ask for another bond hearing. Of the bonds that I'm seeing written right now, but just because of this very recent change, they're being let out at very reasonable rates, relatively speaking. I mean, I had cases where the bonds were around $30,000. Now, if they're going to use those kind of bonds, nobody gets out of jail. But they're letting people out for just a couple $1,000s because they've been here for so long. So you want to get your relative in a position where they're going to be able to assert that and get released from detention. There are humanitarian releases they do that for medical reasons, for example, or if you're the sole breadwinner in the family, they can give you an order of supervision and let you out so you can work and at the same time be able to support your family. If you're a victim of crime and you've applied for a U visa, or if you're a child and you've qualified for special immigrant juvenile treatment, these are all benefits that ICE can take into consideration in deciding whether or not to let you out. And those are humanitarian forms of relief. And dealing with ICE about that is very difficult, but it's the only show in town in many cases. And so you have to learn to maneuver within the ICE framework in order to get the best benefit for your client. Now, what does ICE consider in deciding whether to release someone? First of all, are you likely to come back if there's a hearing? That's number one. Because if they're not convinced you're going to come back, they're not going to let you out at all. Because the whole purpose of bond is to assure the person's attendance at a future hearing down the road. And so that's factor number one. Now, ICE will consider serious illness, particularly if the person detained is seriously ill or if they are the sole caregiver for the relative who is very seriously ill. Now, family support is very important because the more relatives in the U.S. who are here legally, the more ICE can look favorably upon their request for release because the family has obeyed the law and all of these relatives have become legal. That is a big factor, because underlying everything in U.S. immigration law is family reunification. And that goes to the family support for the person. The length of the time the person is in the U.S. is also a critical factor. If you're here more than 7 years and you're a permanent resident, you have relief. If you've been here for 10 years and you have a qualifying relative, you may be eligible to be released. If ICE is convinced you're about to be granted these benefits, in general, they will consider letting the person out. And so these are all issues that come to bear when you're going to approach ICE. And so these applications must be done very carefully, because if they arbitrarily deny the application, there's no appeal. If ICE says, no, we're not going to let the person out, there's no appeal unless you can get back into immigration court. Or you have new evidence to present to ICE. They will look at new evidence if you have it. These days, though, approaching ICE is very difficult. You can't just go to an ICE office. They'll arrest you on the spot. And so it makes it even more complicated because they're arresting people everywhere at this point in time. And so serious illness, family support, length of time in the U.S. those are the threshold items you have to deal with. And then you have to persuade them that it's in the best interest of the United States that this person not be detained any longer. But they're arresting so many people now, and many of them have final orders of removal. When you have a final order of removal, there's nothing. Well, you can still ask for protection under the CAT treaty, but you're not going to be able to apply for asylum in that circumstance. You can also ask for withholding, because withholding is mandatory if the judge grants it. Asylum is discretionary. I had a client detained in a detention center, and I went to visit the person in the detention center, and I came out with a ton of evidence about medical issues with the family, that they have a large number of people in the family, and this is very important, is that there was light at the end of the tunnel because my client had a relative who had petitioned for him, and the only reason he couldn't get out is because the system takes 2 to 3 years to get a green card. And so in that particular case, I was able to show ICE that all we're waiting for is the appointment. He was picked up in a sweep, and he was just picked up. It wasn't because they were looking for him or anything else. And in that particular case, ICE let the person out. Each case with ICE letting somebody out has to be discussed with them personally. They have no blanket policy. It's up to you as the advocate for your client to get in there and convince ICE that it's in everybody's interest that this person no longer be detained. And they let my client out. And because he was about to leave the country and go get his immigrant visa, and he did, and he didn't have an order of removal because they let him out, and they decided to drop the removal case. What's the point of getting a removal order when the person's going to leave anyway? And so, in that particular case, the person was let out, and he was able to complete his time in the U.S. and left and got his immigrant visa. That's a fairly recent case too. And so, there are ways of avoiding removal, and we're discussing the main ones right now. And they go right to the question of detention. If the person has multiple paths to immigrate to the U.S., ICE has very limited reason to keep them detained. ICE doesn't know that to look at the person's face. It all has to be brought to them in the form of evidence when they have a call-in for the particular person. These days, though, when people are getting call-ins because everybody's being arrested, people don't go, which creates another set of problems. But under the circumstances, that's the way it is these days. And in my client's case, I was able to convince them to let him out. Other cases where I've been successful, the person's been let out before and didn't violate any of the requirements for their being in the United States, but then there's a change in policy. Now they arrest the person when they go for their call-in. That's a very difficult situation to deal with, and much of what I'm doing these days is going over everything with clients and deciding, do you really want to take this risk? Because the risks are extreme these days. And once you go into the DHS detention system, it's very hard to get out. Very hard. And so you want to keep the people out of that if you possibly can. In addition, if they're in a detention center, the ability to work with the client, to have a private meeting areas, to have confidential discussions, these are all in jeopardy if it's taking place inside a detention facility. And so the key, I mean, I do cases where the person is detained all the time, but in general, you want to get the person out as quickly as you can. And the other thing is, because it's taking so long to get anything, the government knows that if they arrest you and you want to apply for, let's say, cancellation of removal, it may be years before you get before the judge to assert your case. They can keep you detained. I mean, going back to the cases where I won all 23 appeals, all of those people had spent 3 years in detention. 3 years in detention before they could get relief. And so they're basically, if you're not going to get out from ICE, and you're not going to be able to post a bond, you're going to be in the system until you leave. And they know if they keep you in the system long enough, you will withdraw any relief applications you may have just to get out of the country and get out of jail. So it's a very sad game they're playing, but nonetheless, it's played out all the time, and it happens to my clients all the time.